Okay, so we will now commence the first of our two distinguished lectures this week. It's my great pleasure to be able to present to you Professor Juan Méndez. Juan is currently the United Nations Special Rapporteur on Torture and has previously served in a variety of capacities with the United Nations as an advisor on crime prevention to the prosecutor of the ICC, as president of the International Center for Transitional Justice from 2004 to 2009, and has also, more or less throughout this period, continued to be a professor of human rights law at both Notre Dame University and currently as professor of human rights law in residence at the American University Washington College of Law. As some of you may know, if you've read Juan's autobiographical book, Taking a Stand, Juan is Argentinian originally and was a political prisoner under the Argentinian dictatorship, arrested because of his role in defending other political prisoners that were detained by the junta. After he fled Argentina, after his release, he became in 1982 one of the legal directors of Human Rights Watch and served in that capacity for over 14 years. So Juan is extremely well known and much loved in the world of human rights advocates and professionals. I know that from my own experience, having worked at the ICTJ while he was the president. And I think he is very well placed, I think, to give us this distinguished lecture on the future of human rights. Thank you, Juan.
Thank you, Neil, for that very kind introduction, but especially thank you for inviting me to this very prestigious course. Thank you, and the European University Institute. Heard a lot about this summer course, and it's a real privilege and an honor to be a part of it today. I was asked to talk about the future of human rights activism, and I've been pondering what we mean by that. I will try to use the concept in a very broad, comprehensive sense, meaning everybody who works and every institution that work in human rights protection and human rights promotion, which is a pretty vast universe, because it includes frontline non-governmental groups that take very serious risks to protect the rights and even the life and physical and mental integrity of others. But it also includes international organizations, international non-governmental organizations, some of them very well known. But I will try to include also people who work in human rights as a part of the foreign policy of their own governments, as well as people who toil in the national human rights institutions that have been created in many countries in the last 20 or 30 years, and as well people who work for or in intergovernmental organizations dedicated to the promotion of human rights. You will see that there's been a veritable explosion of these many different opportunities to work in human rights. And although my experience mostly has been with the non-governmental human rights movement, and only lately with intergovernmental organizations dealing with human rights promotion and protection, I will endeavor at least to cover the universe as I see it as complex and varied and diversified as it seems to be nowadays. I should say also that this includes institutions and people working in those institutions that are also that promote and protect human rights from a judicial perspective. Regional courts like the European Court of Human Rights and the Inter-American Court of Human Rights, the African Court of Human and People's Rights, and their commissions, Inter-American and African commissions, as well as the more recent vintage of people working in organizations that deal with international criminal justice, which means, therefore, that we really have a very diversified requirement of different skills and preparation, professional preparation. So it'll be hard to do justice to all of those possibilities, but I hope with your questions and interventions we will cover, if not all, at least most of these possibilities of human rights activism. But maybe it's important to even at the risk of being self-congratulatory, to say, as we always say, that we've come a long way. I mean, none of these many different examples of activism were present even some decades ago. In our lifetime, the possibilities of working in human rights have changed dramatically and have expanded and created. And even if we go back to 1945 and the creation of the human rights canon as we know it today, all of this was non-existent, to say the least. So we went in the area of normative development. We started with declarations like the Universal Declaration of Human Rights, one important human rights instrument, the Genocide Convention of 1948. But then we needed more than 20, or almost 20 years, I'm sorry, to turn the Universal Declaration into binding comprehensive human rights instruments like the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights. But then after that, we also needed another several years at least to be able to put into practice these binding instruments in a way in which we could hold governments to the obligations that they acquired when they signed and ratified them. So we went from standard setting that occupied from the 1948 until the mid-60s to protection, to creating mechanisms of protection. At first, very minimal and with very limited scope and binding force. And even today, we cannot say that we have a strong protection mechanism as we would like to see. And we went from mechanisms that were promotional in nature, that basically encourage states to live up to their obligations, to mechanisms that decided cases and established specific performance by states with respect to those obligations, and particularly when it comes to the mechanisms of protection went from promotional to quasi-judicial and to more firmly judicial. The latter, of course, only in regional mechanisms, because at the universal level, at the treaty bodies, we have quasi-judicial procedures, but even at the treaty bodies, we don't have universal, mechanisms of a strictly judicial nature. All along, and perhaps the emphasis more recently have been on the incorporation into domestic law of those international standards. And it has been obviously a two-way street. The international organizations have interpreted human rights obligations in ways that then domestic courts apply when they understand their role as being the guarantors of the international obligations that states acquire, which is not always the case, but I think we can say it is increasingly the case in many countries around the world that judges and courts take seriously the responsibility of incorporating international law standards into domestic precedent and judicial decisions. All of these changes that have happened since 1948 have been facilitated by what we could consider human rights activism. That for some time it was mostly academics and professors and jurists that took interest in this. Then a second phase, if you will, was provided by volunteers, mostly individual men and women who took their concerns about the practice of human rights in different parts of the world, and mostly through membership in organizations like Amnesty International, found a way of having that concern be translated into specific action. But more recently, we also had organizations of professionals like the International Commission of Jurists who also brought these concerns to the fore, mostly by dialogue with governments. And these networks of concerned citizens then generated their own groups of individuals. I wouldn't call them bureaucracies, although some people would call them that, but people who were permanently employed by Amnesty International, by Human Rights Watch, by other international organizations, and who developed a certain professionalism around this full-time dedication to investigating and fact-finding, but also monitoring and advocating for human rights change around the world. This professionalization of the practice of human rights brought with it more sophisticated methodologies, including of fact-finding, but also methodologies of advocacy and being able to dialogue with states. A lot of it, especially in the 1980s, turned around the issue of insisting on the foreign policy of certain states to promote human rights elsewhere, with its limits and its especially problems with the perception that that some of these human rights organizations were too close to powerful states. I think nowadays we see some changes in that I'll try to mention in a few minutes. But the important thing is that in order to be effective in proposing to states that their foreign policy should include, for example, sanctions to states that were well-established violators of human rights, it also meant that in order to succeed in that endeavor, you needed to demonstrate a capacity to find out what the facts were and engage in the debates about those facts with the responsible government, but also with forces in the central countries that disputed the facts because of some interest in protecting client states, etc. So it is in that period where especially the leading international human rights organizations developed fact-finding methodologies that included not only determining when a violation can be said to have occurred, but also when to recognize the value of testimonies by people who were victims or were close to the action. And that happened not only in human rights violations, but also in conflict situations. And so human rights organizations, at first reluctantly, but then embraced the need to understand the loss of war and to be able to obtain testimony about how the loss of war, especially in the protection of civilians, for example, might have been violated in specific instances. This professionalization also brought about a more sophisticated way of using the media and making the findings of the fact-finding on the ground be translated into the larger public, because it was and still is important to be able not just to represent what goes on in a given conflict situation, but to engage wider and wider circles of societies in the concern for improvements in human rights in other parts of the world. But along the way, I think we can identify that there have been new human rights constituencies that have appeared, and particularly this is true of the latter days, because first and foremost, I would say the frontline human rights defenders have become a principal actor, and an actor that they don't depend anymore on the cover that international organizations such as Amnesty or Human Rights Watch can provide. That might have been at some point an important contribution, not only to their work, but also to the survival of people who were doing human rights work in the front lines. But nowadays, I think it can be said that these organizations have come onto their own, and they have formed South-South kind of networks, and they cooperate with each other, and they have established, to different degrees, of course, but they have established international presences on their own. There are organizations now from the South that continue to do mostly work in their own countries, but that also have an ability to express their concerns about what happens in countries of a similar economic and political development, and are able to link themselves up with frontline defenders in those countries as well. And their voices are heard in Geneva, in New York, before the regional courts and commissions as well. So I think this kind of independence of the frontline defenders is a feature of the present composition of human rights world. I think this is especially true in one area of international human rights that we, for lack of a better terminology, quite frankly, we call transitional justice, in the sense of what governments are expected and are obliged to do when they confront a legacy of very serious and widespread human rights violations, and they have to give satisfaction to the victims of those violations, especially during a transition from dictatorship to democracy or from conflict to peace. The principles that we now tend to identify with transitional justice were mostly pioneered and championed by domestic human rights groups in those contexts. And of course, I have to say that international groups like Amnesty and Human Rights Watch embrace those principles as well, but they actually took their example from domestic groups in those transitional situations. but in addition to frontline human rights defenders, the human rights movement now is increasingly formed by specialized organizations of especially vulnerable victims of certain human rights violations. And by that I mean, for example, indigenous peoples that bring forward not only the questions of attacks on life and physical and mental integrity, but also on livelihood, and we have come to understand a broader conception of what the right to life is, when it also means a right to survival as a culture. They also bring to our ability to understand questions like the impact of certain productive activities like mining and logging into their possibilities of survival as a culture. And in that sense, they have shown the way to integrating economic, social, and cultural rights with civil and political rights in manners that we wouldn't have been able to do without their experience as indigenous peoples. I also would like to mention ethnic and racial and religious minorities that provide to us the example of what it means, especially to have minority rights in a democratic context by way of the rights to language and to language services, education, but also in how to understand discrimination when it comes to violence, especially state violence. Minorities have led the way to make us understand that some forms of investigating or not investigating violations by the police, a lot has to do with the racial composition of the victim, or ethnic or religious composition of the victims. Of course, we should mention gender perspectives on human rights that have become an essential component of not only what comprehensive human rights groups with a comprehensive mandate do on a day-to-day basis, but also by specific groups of women that instruct us on how women experiment and experience specific forms of violation, and therefore we need specific remedies for those violations. So those gender perspectives on human rights have changed dramatically when the feminist movement entered the human rights movement and basically took it by storm, to say the least. And nowadays, especially, we see a similar emergence of lesbian, gay, bisexual, transsexual, and intersex groups entering this area. And I think their ability to convey to larger sectors of society their interest in non-discrimination because of sexual orientation, it can be seen in many countries around the world where, for example, same-sex marriage is more and more adopted and agreed upon by large sectors of society. This doesn't mean, of course, that the struggle for equality of LGBTI people has ended by any means, but I think for some of us who have been in this work for a long time, it's very noticeable that non-discrimination on the basis of sexual orientation has become mainstreamed into the work that we do. I would also mention persons with disabilities, and there are specific groups that work on not only the right to health, but the right to a life free of violence for people with mental disabilities, for example. Groups of users of psychiatry, as they call themselves sometimes, are also leading the way. Not that their perspectives are always non-controversial or readily accepted by everybody else, but they are transforming the way we look at human rights, and not only as practiced by state authorities, but also in healthcare settings. And of course, children, especially with the ratification by almost every state except the United States of the Convention on the Rights of the Child, is also an example of how the special concerns of children have entered the mainstream of human rights protection in many different ways. And it's not just in the normative development, in the normative framework, but the normative framework for the rights of children permeates and affects the way we look at, for example, incarceration and due process violations, the treatment of children in custody. We can say now, and I think we can say it only recently, that there is a customary international law prohibition on the death penalty to be applied to people who committed their crimes when they were under 18, which is something that we, maybe championed some years ago, but we couldn't say as a matter of normative development that had already happened. And of course, all of this means that we have come to a better appreciation of how economic, social, and cultural rights and civil and political rights must be interdependent and integrated. I have to say that I think that we still don't have the same level of ability to promote and protect economic, social, and cultural rights that we have achieved over the years for civil and political rights. That we are still struggling to find specific ways in which we can, on the one hand, make economic, social, and cultural rights justiciable, and also how, in practice, to implement the progressive realization standard that is appropriate to economic, social, and cultural rights. I think we're getting there, but the human rights movement has a challenge in either finding the proper way of promoting and protecting economic, social, and cultural rights, or integrating them into the way we already do protection of civil and political rights and provide remedies for civil and political rights. But at least I think we can say that over all this time, we have left behind questions of negative versus positive obligations, or questions of economic, social, and cultural rights being resource dependent and therefore not immediately applicable, etc. At least as a matter of arguments, we have left them behind. As a matter of actual practice, as I said, we still have some ways to go. I think these organizations with specific agendas, have left behind the early debates that we had, especially in the larger international human rights organizations, about the need to have a narrow mandate so that we could be effective. I know because I was one who argued that the narrow mandate was a way to be specialized and therefore effective. But I think nowadays most organizations, even local or national organizations, also adopt what is called the full spectrum of rights as part of their mandate, and then develop specific ways of promoting and protecting all the rights in specific situations. Now, I guess I've been talking more about the present and the past of human rights activism and very little about the future, but you will understand that I don't have the ability to predict the future, and I wouldn't want to be caught attempting to and then being proven completely wrong. But I do think that what we can say is that we still have large gaps, large challenges that we don't seem to have a good handle on. I'll give 3 or 4 examples, and for all of them, there's already some realization that we have a challenge and some ability to bring forward the specific agendas of certain marginalized groups, but at least with respect to the constituencies that I've already mentioned, for the ones that I'm going to mention now, I think it is safe to say that we lag behind. And I would like to mention specifically the rights of persons deprived of freedom. We have long had specific organizations that deal with prisoners' rights, and the normative framework has been around for a long time. The standard minimum rules for the treatment of prisoners is one of the better known documents by the United Nations, and it's with us since the 50s. But nevertheless, our ability to defend the rights of people who have lost their freedom on account of being incarcerated pursuant to either a conviction or in pretrial detention seems to be lagging far behind. This year, we have seen a review process, a very encouraging review process of those standard minimum rules that will incorporate some important new standards. And it was very gratifying to see human rights organizations, again, from both the highly developed world, but also the developing world, participating in those debates and pushing for standards that some states were very reluctant to adopt. Obviously, the standard minimum rules are non-binding. They are a very good expression of the international concern for humane treatment of everybody in detention or deprived of freedom, because they will apply also to, say, for example, people in mental institutions. But our ability to act on the specific rights of specific persons incarcerated, for example, subjected to solitary confinement in many parts of the world, or subjected to overcrowding and inhumane physical conditions of detention, is still one of the challenges for the human rights movement. I would also mention the rights of minorities against police abuse. I live in the United States, and so you may have been familiar with the already all too numerous examples, not only of tendency by police in different parts of the country to be too quick to shoot to kill people because of their race or minority status, but what's even worse, the tendency for the investigation and prosecution of those cases to be quickly watered down, or policemen to be exonerated too quickly by prosecutors. I think in the United States the matter is visible, but it happens in many other parts of the world as well. And despite the fact that we have some important precedents, like the European Court of Human Rights when it came to police abuse of Roma people in many European countries, we still don't have a strong constituency to defend the rights of minorities against this kind of abuse. And I think we should also mention migrants, migrant workers, and and boat people more generally. Not only boat people, people who cross land borders as well. This has long been a serious problem in many countries, and nowadays, especially the United Nations is trying to bring it to the fore. But I think also that we are far from being able to say that migrants are protected from the violation of their basic human rights in many parts around the world. Let me inspired by what Philip was saying earlier this morning, I want to mention some fact-finding that has some problems of fact-finding that have a bearing on what I'm trying to say here as well. In the special procedures, we have the problems that Philip identified with the limitations of our fact-finding. In my case, the special rapporteur on torture has a very hard time getting invited to visit countries. Fortunately, there are so many countries around the world that I can say that I've visited some very important countries as well. But there are countries that we've been waiting for 25 or more years to get an invitation, and we don't even get responses anymore. In my last report to the Council, I made a special point of not only highlighting the fact that states refuse to invite the special rapporteur on torture, but that some invite us and then disinvite us at the last minute, or invite us and violate the terms of the invitation, like I had once we were in country, like it happened to me last year in the Gambia, where after agreeing to terms that included being able to go to every detention center, the government denied us access to the maximum security wing of the main prison in Banjul, and we had to decide whether to cancel the visit or complete it. But I have to say that unfortunately, obviously the countries where there's lots of torture and I should try to go are also the countries that are never going to invite me. But surprisingly, I have the same problem with countries that you would expect to have, would have a better way of dealing with whatever problems of mistreatment they can handle. And for example, I was invited to visit Guantanamo, but on terms that I could not accept. It were the same terms that my predecessor was given back in 2004, at the very beginning of the use of Guantanamo. And when I asked to be invited again in 2012, I got exactly the same terms, meaning a guided tour of some parts of the prison, not all of them, and specifically without the ability to talk to any inmate there. So of course I had to decline that invitation while insisting that I wanted an invitation on terms that I could accept. The Russian Federation also has invited me, but they say that every interview with any inmate has to be approved by the prison authority. And of course I can't accept those terms either. And I have asked the United States to invite me to visit prisons in the mainland, particularly state and federal prisons where solitary confinement is a large issue. And I've been waiting for more than 2 years now, and I still don't have a firm answer as to whether I'll be invited or not. But back to our point, I have to say that on matters of solitary confinement, the civil society organizations in the United States have done a wonderful work on that and have brought the issue of solitary confinement to the forefront of preoccupation. And there are even conservative thinkers and conservative politicians who have come out against the excessive use of solitary confinement. We're still a long way from solving the problem, but at least in some states there have been litigation and judicial decisions and settlements that, for example, prohibit solitary confinement for juveniles or for anybody with mental disabilities. Of course, solitary confinement for other prisoners is also a problem, especially prolonged or indefinite solitary confinement. But this is something that, that human rights organizations are beginning to put a whole lot of focus on. And I should say that solitary confinement is far from being the main problem in the United States. It's the European Committee on the Prevention of Torture, CPT, out of Strasbourg, has said that solitary confinement is used even in Nordic countries, particularly for pretrial detention, when the judge establishes that there is a possibility that that the detainee might disrupt the investigation of an organized crime situation by reporting to the outside world what the interrogation is. Now, some of those things are legitimate uses of solitary confinement as long as they are limited in time. But, you know, if it may legitimize some isolation for, say, a few days, maybe even 30 days, and as long as the conditions of solitary confinement are somehow mitigated, they certainly don't authorize prolonged solitary confinement of, say, a year or 2 years, even for the purposes of not disrupting ongoing criminal investigations. In many other countries, solitary confinement has crept up. In many Latin American countries, for example, the prison regulations allowed for disciplinary isolation for up to 3 weeks or 4 weeks. And even in this democratic period in most Latin American countries, the rules have been changed without anybody really noticing. And now in many countries, it's possible for prison authorities to put someone in isolation for up to 9 months or 6 months, etc. Again, there is some challenge going on. As the Special Rapporteur on Torture, I filed an amicus curiae brief with the Supreme Court of Brazil that is entertaining a challenge to the regulations on solitary confinement. I also have to say that our problems with fact-finding in the special procedures affect our communications as well. Communications is the term that the United Nations uses for the case complaint mechanism. It's very rudimentary, very unsophisticated, but we do present to the public that we entertain individual cases under our mandate. So if somebody is being tortured anywhere in the world, they can, or someone on their behalf can write to me, and I can use a procedure that we have for communications. Unfortunately, it's basically just an exchange of notes with the government. And exchange is sometimes too much to say, because in about 50% of the cases, we don't even get a response. So, and I've made a point of making sure that at the end of the process, we say something about whether a violation has occurred or not. We write what we call observations report. Just because of sheer lack of resources, we can do it only once a year, but we take all the cases that are ripe for a decision that we work through the year, and we try to write a short excerpt for each case as to what the facts are and whether or not a violation has taken place or not. But even those communications have given rise to intemperate responses, to say the least, by some states. On the one hand, for example, in my last report back in March, Australia took offense at what I said about the mistreatment of some Cambodian boat people who had been intercepted in the high seas and kept in an island offshore of Australia, and then forced to return to Cambodia. And on the specific conditions of their detention is what I had to deal with. And the fact that they might be legitimate refugees, or even if they're not legitimate refugees, the standard in the Convention Against Torture is that no one can be returned to a place where he or she can be tortured. So even if they don't qualify for refugee status, the obligation of Australia was to give them a fair hearing on whether, if returned, they might suffer torture. We had, as I said, a very intemperate response by the government of Australia, and even hate mail from Australia. I have to say that I also had a lot of support from Australians, individual and institutional Australians, supporting what I said. And similarly or simultaneously, I had a serious problem with Mexico, where I had done a country visit and a report, and the government generally accepted my recommendations, but took very strong offense at what I said, that torture was generalized in Mexico. And I explained why I meant it was generalized, but the government purported to say that my methodology for determining that torture was generalized in Mexico was flawed, and that I myself had recognized that the methodology was flawed. And they took a clip from my report in which I was answering to the Australian delegate who had challenged me, and I said that the methodology for individual cases was rudimentary and unsatisfactory, because, as I said, it's just an exchange of notes. And the government of Mexico claimed that I was talking generally about the methodology of fact-finding, even in country visits, which of course I was not. I have to say that when we are challenged like that, and especially we're challenging a country that has a very broad respect for freedom of expression, we have the ability to have our point of view known to the public. And so both in Australia and in Mexico, I feel that my views were properly represented in the debate. And again, the NGOs, domestic NGOs in Australia and in Mexico also participated in the debate and in an important way, preserved the debate where it should be, not on my personality or my ethics, but on whether the facts warranted what I said about the one case in Australia and the general practice of torture in Mexico. My final point that I wanted to leave with you is that we have really yet to get a grasp on how do we prevent violations from happening in the first place. In the case of torture, we have a system. The prison visit, basically pioneered first by the Committee on the Prevention of Torture in Europe, and now by the Subcommittee on the Prevention of Torture as part of the optional protocol to the Convention Against Torture. And it's something that's very encouraging. I mean, you develop a number of people who really know how to visit prisons, and a methodology of making sure that you get the right picture and not not the Potemkin village, picture of a prison. We, by the way, do that also when we visit prisons ourselves, and we learn a lot from each other. But except for some efforts on prevention of genocide, and even those, very unsatisfactory, the human rights movement has learned how to react to violations, but is still learning on how to make sure that we don't have the violations to begin with. And of course, it's a lot harder to know whether we are successful or not, because the violations that never happened, who knows why they didn't happen, right? But I think, in fact, we need to try to focus a little more on prevention. For now, what we have on prevention is this obligation to investigate, prosecute, and punish. Genocide, torture, disappearances, crimes against humanity, that's a main feature of that, and war crimes. The Geneva Conventions say explicitly that war crimes cannot go unpunished. And now we have an institution like the ICC. But we are putting all our eggs in the basket of preventing through punishment. And I still believe very strongly on it. But I think it only works if we do a few other things as well, together with punishing the violations that have already happened, because otherwise it's a leap of faith. We believe that by punishing this violation here, we prevent the future violation from happening, but who knows? And that's where Neil and I have worked on transitional justice precisely because we think that the principles of transitional justice, give a broader picture of what you can do to prevent violations from happening. One, by establishing the obligation to prosecute and punish the ones that have already happened, but also complementing that with, say, forms of protection of people who are at risk, coming to grips with the underlying conflict by peace negotiations, and in the case of displaced persons and refugees, by providing humanitarian assistance, because people are victimized in many different ways. They're not only at risk of being killed, they're also at risk to health and welfare and livelihood, and the international community has to come to their rescue in many different ways. All of these are very preliminary questions, but I wanted to finish with this question of the challenge for the future, in addition to all the other challenges, is coming up with proven ways of preventing violations from happening. I really appreciate your attention and your questions. They've been great, and if I didn't recognize somebody, maybe we can continue in the hallways. Thanks very much.